15
There he
seconds.
is. William. You don't want to be up front?
Oh, we got a seat for you right here, buddy.
Not as big, not as full as the last one.
Okay, it is 1:30 and it's a time on our schedule for a planning hearing. Today, we're going to be hearing file BS 0002-21, and it's a vacation of a portion of Camp Bay Road with Green Enterprises, Inc. Before we get started, does anybody have any visual or hearing impairment that they might need help with? Of course, if you have a hearing impairment, you probably can't tell what I'm saying, but I always like to open with that to soften everybody up a little bit, you know. I do. It's the same shtick every meeting. Is there any, let's go ahead and call for conflicts of interest by the commissioners.
Commissioner Conley has no conflict.
Commissioner Bradshaw has no conflict.
And Commissioner McDonald, I have no conflict. With that, I will not go over the public hearing procedures because they're right up there. And it'll save us a little bit of time. So I'll give you a quick rundown. What you're going to hear, staff report. Then you're going to hear the applicant. Then we're going to take public testimony. We'll usually start out with those in support and then those that are neutral, which I don't know how that makes any sense, but, and then at the end, we'll go do with those, we'll go after those who were opposed and they'll have an opportunity to speak. At the end, we will close the comments. Commissioners can ask anybody at any time, any question. Please don't try to speak over other people. We'll recognize you. Direct all your comments to the chair, which is me. Once we close for deliberation, there'll be no more public comment. Or actually, I did explain it. Never mind.
Good job.
So with that, I will turn it over to Milton
you know, I
Arlington
would.
to give the report.
All right, thanks. Good afternoon, commissioners. So here we go, Title 40 vacation. The petitioners seeking to vacate a portion of a dedicated right-of-way labeled on the maps as end of Camp Bay Road, shown on the submitted site plan. So it's approximately 2,550 linear feet, 2.93 acres of the Camp Bay Road. This is a picture of the submitted site plan. This is a picture of the road with all the topography turned on as far as wetlands and sloping. So when we look at the back data on this, the site data on this, you'll understand what we're talking about. You can see that there are slopes around on the sides of the road, but the road's not impacted by the slopes or the wetlands. But this is roughly a portion of the road that's proposed to be vacated. We noticed the neighbors and we sent it out to agencies. There have been no agency comments. There have been several public comments with varying comments, some in favor, some opposed. Roads being county maintained for 40 years, establishes public access to Lake Pend Oreille. Proposed road improvements will be a benefit to the residents. Moving the road, provide for greater protection of Lake Pend Oreille. Enthusiastic supporters of the project. Gated road is not in the best interest of residents who live on or around the development. So those are just a highlight of some of the comments received. There's definitely a lot more than that in the file, and I hope you enjoyed.
Yeah, we read through them all.
So staff's purpose here today is to review the project against the laws. There's a lot of data or a lot of information that came in the public comments that staff won't even consider or look at. It feels good. It looks good. Those comments are not for the planning department to review. Planning department is to review the concept of law. So that's what we looked at. The applicant, again, it's approximately 2.93 acres, minor sloping, hoodoo silt loams. It's a county maintained road. The road has probably been in since about the time the lake was made or something like that. I mean, it's been there a long time. It's a gravel road. And we reviewed it against state code, the proposed vacation will take the roadway out of the county maintenance system. So it will become privately maintained. There's definitely some benefit to that, to take this short of a road out of, or take this short portion out and let the private owners maintain that road as it goes across private property. There is no public access to the lake as the road ends at the high water mark. There's no area at the end of the road that allows for somebody to stop and park and go enjoy the lake. It's the road ends there. And so if somebody were to stop and use the lake, they would be stopping in the roadway. So there is no public access from that perspective. Proposed road improvements. So the applicant's proposing to take the road out of maintenance system, but then maintain it themselves. And the road improvements that they've included will definitely improve the area. Some of the things they put in the application indicate that they'll be moving the road further away from the lake, increasing setback scenarios for structures and septic systems. They'll be adding turnarounds at the gate for a school bus or snowplow. So the proposal is well planned. The new proposed road is well planned, well designed, and the key with taking something out of public ownership is that the replacement will be able to fulfill the needs that already exist with this current access. And that has been proposed with this application. So future maintenance of the road will continue at the petitioner's expense. So conclusion one, the proposal was reviewed for compliance with the vacation criteria set forth in Idaho Code Title 40. Finding that vacating this road will not block access to surrounding parcels. You have in your file a copy of the proposed easements, proposed boundary line adjustments that are to be completed at a later date. Nevertheless, you have the proposed easement. The abandonment, conclusion two, the abandonment of the public right-of-way is in the public interest. So the proposed vacation provides for continued access to properties beyond the subject parcel. Again, this is the importance or the urgency with taking something out of public ownership and putting it into private, is that those subject parcels will continue to have access. The benefit is that again, the road will be out of the county maintenance system, be shorter turnaround for the county employees, not having to go all that way down. Nevertheless, the improvements that are planned for this area will allow the property owner to develop his property and move the easement as he needs to for quality development, all right, for good development. And that's some of the challenges when you look at a large piece of property that has a right of way through it. Sometimes the proposed development doesn't fit with the right of way where it is, and it needs to be moved. So in this case, the request is to take the public right of way out of public ownership and allow them to work it the way they need to for the best of their development, right? So they can create the best product for their customers and for themselves. All parcels, again, I'm just repeating myself with each of these conclusions, but nevertheless, you have in front of you that the proposed easement and how this will all be taken care of in the future. So staff has found that it's consistent with Idaho Code, that it is in the public interest, and that we would recommend approval.
Okay.
So,
Do any of the commissioners have any questions for staff?
Yeah, the vagueness part of the, I guess there's obviously a description of the road, but on the conditions of approval, it says approval is proposed vacation will be on condition of upon recording of the proposed boundary line adjustments and easements showing access to the properties beyond the subject parcel. One of the issues that comes to mind for me is that shouldn't it be already constructed before we vacate? Because, I mean, you're trading, road for road. Does this become an issue? Possibly even for the county?
It doesn't, because you've got two things going on here. Maybe council would be best to answer that question. But you have the public right of way that's being vacated that is still going to be in use while the easement is in place and being developed. And so you can't close one without opening the other, right? So it's happening at the same time.
That easement is part of the
Happening together.
conditions for approval.
Correct.
So until that easement's filed, technically it's tentative approval. If we approve it.
Yeah, this does not get filed until that easement. No, not until the easement has been approved and recorded as well. So, but then they just work contiguous, and the applicant can probably speak to that much better
Yeah,
than I can. So,
sure.
Okay, Steve, any questions for staff?
No, I did lots of work out in the Camp Bay area over the years, and I know there's a lot of houses that turn right when you get to the lake and go around there. In the event something happens to this development thing and we vacate the road, our authority stops at that property line. If we vacate that road and we're no longer able to help the landowners who now are landlocked because maybe the company went belly up or something, what's going to guarantee and protect them from that? Now the county have to go back in and take it. They can't do that
Sounds like a
if
bill
we
question.
vacate it.
So, my name's Bill Wilson. I work for the prosecutor's office and I advise the board and planning staff on issues like this. I think if I'm understanding your question correctly, I think that might loop back to what Milton was trying to describe, which was when you do something like this, that is essentially a conditional vacation contingent upon the provision of a suitable alternative route, then the original portion is not vacated and cut off from public use until
The new one is
the new
built.
one is provided. And so does that answer your question?
Yeah, so once the new easement is provided, it's a legal document and it would cover that.
I think-
Cover that
does
access
answer your
regardless.
question, Steve? Okay.
Yeah.
Okay.
Anything else, gentlemen? Seeing none, let's go ahead and hear from the applicant or the applicant's representative. And make sure you identify yourself for the record.
So you just click on that right there on the, it goes on to the next screen.
Okay. I'm Brad Marshall, I'm a senior planner with JEV Engineers representing the applicants. With me today is Jeremy Russell, our survey manager, and also available is Paul Doherty, represents the Green Enterprises, the Green Corporation. Again, Green Enterprise in association with N3 Development is the applicant. As Milton said, we're seeking a vacation of about 2,500 linear feet of road. It really is, as Milton said, to kind of provide a better design of the overall project and remove that road, provide a new road, a little more flexibility. Provide that new road will meet your county road standards. This is an exhibit map that Milton provided. We've kind of highlighted that area that the vacation would occur on. Bear with me as I'm going to get used to your mouse. So again, it extends from the north end of the green property to the high water mark of the lake. So it's that yellow road there. We've had an opportunity to review the public record, the public comments that came in. There were some questions with some of the members of the Green family as to Jim Green, the controlling partner of the Green Enterprises' ability to seek the vacation, sign the application. So we've responded to that with a letter. That clearly, Mr. Green is the controlling partner of Green Enterprise and has the right to file that. In addition, Jim submitted an additional letter beyond signing the application that speaks to that. He's the controlling stock owner of Green Enterprises, and again, he supports the vacation that he is seeking. As Milton probably mentioned, there is half a dozen or more homes to the south of the green property. This is called the South Camp Bay Road, that have an access easement through the green property. We've had many, many meetings with them and have a dialogue there. And we have the support of many of those property owners to vacate the right of way and provide a new access easement. There's a letter into effect from Mr. Jim Frank and others that speak to that support. It's important that that existing easement to the South Bay Camp Bay property owners has flexibility to be relocated. So we are proposing to relocate that. In the end of the day, we'll have a relocated easement in a brand new paved private road. Also, a key point is that the South Camp Bay property owners will be provided gate access through read cards and codes, so they'll be able to go through the gates very easily, just like anybody else in that area. Good questions regarding how the sequencing of the easements and kind of how that works with road construction. I'm going to kind of try to talk through that. So this is the new road alignment right there. Fundamentally, in many ways, very similar location as the existing road today. And then this is an existing kind of road that runs right through here as well. And then this connects to an existing easement here. So our proposal is that we reconstruct this road. It becomes a permanent easement. This becomes a temporary easement. And then as we develop this road, which will require a removal of one home, again, these are all brand new paved roads. So we'll develop this road and then we'll extinguish this temporary easement here. And ultimately, this will connect to that existing easement. So there will be actually no point in time where there is no physical access to those South Bay Camp property owners. In addition, they will always have a legal access and utility easements as well. There's kind of some questions about the sequencing of kind of how it works. Ideally, we see the vacation process being approved, contingent on the easements being recorded. We will record those easements. And we'll record the boundary line adjustments that kind of puts it all together. So we want to assure those property owners to the south that they will always have a physical as well as a legal access to the property through the green properties. And again, we'll be working hand in hand with Milton and the staff to make sure that there's comfort there. I want to take a little bit, talk about, I call it the historical overview, difference between maps and legal descriptions. Often when we create an easement, you create a right of way, you have a legal description that's prepared by a surveyor and an exhibit map that's attached to it. And if you look back at what's called the 1908 viewers report, that's a map. It shows the Camp Bay Road and it shows a defined end, but it doesn't really show where it sits with the lake itself. If you look back, and I'll show you those maps to you in a minute. If you look at the 1939 Metzger's map, those common maps that have been around forever, really kind of shows the same thing. It shows a road, but no connection to the lake whatsoever. If you look at today's Bonner County Assessor's map, that's the map we all use and take a look at every day. Again, it shows no connection to the lake. And in fact, it actually does not even show a public right-of-way there on the Assessor's map. So one would argue that the county has been assessing the Green family for well over 100 years for this right-of-way that's actually on their property. And I'll kind of get into that in a minute. However, the legal descriptions attached to the original right-of-way dedication, the legal, does show to the high water mark of the lake. So that's why we requested to the high water mark of the lake. So again, this is that viewer's report. And bear with me, that's the center line of Camp Bay Road, kind of running down into the lake. And it shows a terminus point at Camp Bay, but it really doesn't show where does it sit in relationship to the lake itself. There's a couple of lines that kind of potentially indicate the lake, but what is that high water mark? This is that 1939 Metzger's map that I mentioned. And again, you kind of look at the Camp Bay area and you kind of look at those roads that Camp Bay, that road that kind of drops in there. Kind of hard to see, but there's no connection to the lake whatsoever on the Metzger map. We looked at some historical photographs. They're always fun to look at. And we were looking for that connection to the lake. And this is a 1922 picture looking to the south. Again, no road connection to the lake. Another 1930 picture looking south. Again, no road or access to the lake. Fun pictures too. Again, looking, this is kind of looking northeast. Again, no connection to the lake or the road itself. This is kind of a pretty interesting and illustrative map. This is that county assessor's map. This is the one you pull up every day. And again, the blue lines on the map indicate the boundaries of the green property. You kind of see that. The red, again, indicates in generality what we're proposing to vacate. The lime green or the green indicates the current property lines of the adjoining parcels. And what's interesting is you look to the north of the green property, you'll see this nice defined right-of-way there that kind of provides access to the people to the north. But as you drop into the green property, that right-of-way is not indicated. There's a road there. There's a road right-of-way we're seeking a vacation of, but it is not on the assessor's map whatsoever. And certainly no connection to the lake itself. And again, one would make the thought that the Greens have been paying property taxes on this property since time began. And I've had some conversations with the county assessor regarding kind of how that works with timber and so forth. And I understand that it's really based on the timber on the property, but nonetheless, it doesn't show. Trespassing, private property issues. It's been a challenge for a long time in discussions with the Green family and the representatives. The property is well posted, but they continue to have trespassers and issues down there, whether or not it's hunters or people trying to access the waterways or use that shouldn't be down there, what I used to do probably. But nonetheless, there's been 21 times that the Sheriff's Department has been called out to the property to deal with those trespassing issues. And we hope that through this vacation process and the development of private roads, all those maintenance and access and trespassing issues will ultimately be addressed. And you won't have a sheriff having to go out there and respond to those challenges. This is a very current picture of the property. This is near the terminus point of the road. This is looking southwest. What's key to this picture is there's no access to the lake. I mean, there's no boat ramp, there's no boat trailer parking, there's no public restroom. There is no stairways, walkways, ADA access. There is just nothing there. And nor has the county ever exercised any maintenance responsibilities toward this area of the lake. So there's just beautiful beach, but nonetheless, nothing there. We'll take a little bit of time and talk about kind of some maintenance things that have occurred in the past and things that are going to occur in the future. The Green family historically has allowed the snowplows to turn around on the property, school buses, the mailman to turn around on the terminus of the property informally, but in no such way is there a easement that speaks to that ability to do it. So it's been a handshake and an informal approval to do that. As part of this vacation, we'll actually back up that road to the north end of the Green property, and we will construct a brand new turnaround for snowplows and school buses.
To county standards.
Yeah, absolutely. Absolutely to county standards. And we've had a lot of discussions with the county. We have a good grasp of that. So again, we're backing it out. We're building a new turnaround. Again, we see no really public benefit to that right away at this point. Certainly doesn't get to the lake. I've kind of touched on it already, but I think it's kind of important again is backing out that right of way provides a better design, it provides access to the South Bay property owners, a new paved road. We've got the support of many, if not all, of those South Bay camp property owners. We will certainly be working with them as we move forward. We have kind of monitored, and rightly so, the public comment that's come in and any type of agency comments that have come in. One of which what got our attention was from Mr. Arn. And he speaks in his letter is regarding, what he says, whether the proposed vacation violates the public trust doctrine. The public trust doctrine is codified in Idaho Code 58-1201. And it's really, when you really look into that doctrine, it really looks to the sole limitation on the power of the state to eliminate the title to the beds of navigable water. And we want to emphasize title of the beds of the water. In this case, we're talking about Camp Bay Road, not the bed of the lake. So we see that almost as a moot point, and you don't see the relevance of that. Another comment that came in from Mr. Arns, and in all due respect, he speaks of the Navigable Waters Act, and we're a little unclear on what he meant by this, but we took some assumptions there. He's claimed that Camp Bay is a water of the United States, and pursuant to the protection discharges of pollutants to the lake. And again, I want to remind you that we're talking about the vacation of Camp Bay Road, not certainly not the navigable part of the lake itself, and no impact there whatsoever. We do want to touch on one part, is that historically, this is a gravel road, and particularly July and August, September, it's dry, and dust has been a significant issue out there. Plumes of dust that come up and settle in the valley, settle on the lake. And with the reconstruction of this, we'll have a brand new paved road, and we'll mitigate those dust impacts for all parties involved, including the water quality of our precious lake. I touched on this. I want to talk a little bit about the maintenance costs. Again, we're backing out that road. We'll take on the responsibility of obviously reconstructing the road as a private road and maintaining that road in perpetuity through an association. So there'll be a collection of a fee. There'll be a maintenance mechanism. We'll work with Milton staff to make sure that's all copacetic. And also what it does is that eliminates those public-private road conflicts. So in regards to maintenance, they're always a hassle that we always get calls on. I used to work at the county, and I used to get those calls. So I'm certainly familiar with those conflicts of where do we put the snow, who's maintaining the road. I'm paying taxes, so we're gonna, we'll ensure a nice, clean maintenance mechanism for these roads and alleviate the county's responsibilities. Key point, we've had a chance to look at your own comprehensive plan. That's your long-range plan for the community. There's no mention of specifically of Camp Bay Road. It's not in your transportation element of the comprehensive plan. So I think that's a key point as well. I probably should have mentioned this before, but the width of the right-of-way is just 50 feet. 50 feet. And when you think of developing a public access, 50 feet is not adequate for a boat launch, trailer parking, public restroom, ADA requirements, solid waste facilities that are all needed with good public access. So I think that's a kind of a key point that this just isn't a good fit. And there really isn't opportunities for the county to buy additional ground in this area. So it's just a limited strip of land. And also key point is there is public access or access to the lake at Garfield and Bottle Bay, which is just a couple minutes away. I've talked about reducing maintenance costs, improving access to the South Camp Bay properties. Development of this property will increase property tax revenue. There's significant opportunities here for the county. Again, we'll provide a gated entrance. We'll provide gate codes and securities to those south of the gate. Like Milton, the staff did, we also looked at Idaho code, and we also looked at your county codes. How does this application kind of fit with that? So we provided that initial criteria and addressed that criteria. And again, my apologies for covering some things twice. Again, we believe the abandonment of the right-of-way is in the public's best interest. It will reduce maintenance costs. It will continue to provide access to those adjacent owners to the south. It'll eliminate those public-private road maintenance conflicts. It will reduce, maybe eliminate those trespassing calls to the sheriff. Um, Key point is, one of the criteria is that landowners abutting the right of way do have access to his or her property from public right of way. So the green property will still have a public road that connects to the green property on the very north end. We're just backing out the right of way that's within the property. So they'll still have access. And those property owners to the south will continue to have an access easement and utility easements to their property that's fully developed and again, a brand new private road, paved road. And it's to our benefit to work hand in hand with those adjoining property owners, of course, the county. So we certainly want to do that. I guess in summary, we're respectfully requesting approval of the vacation based on the following. The Green families own this property for 120 years. One might argue they pay taxes on this right away for 120 years.
You're not looking for a refund, are you?
Nope. Good question, but no, thank you. This
You
is
kept hitting on that. I kept thinking,
I know.
what's he getting at here?
No such thing. The limited right of way, it's not viable for public access. You just can't fit a boat launch in there, trailer parking, restrooms, ADA requirements, solid waste receptacles and those type of things. I think we'll look forward to enjoying or minimizing those public-private road maintenance conflicts. Your planning staff has recommended approval. This has been routed to the agencies for public comment, none of which have opposed it. So the agencies would arguably be supportive of it. With that, we again respect approval and thank you for considering it.
The only comment I had was the one bullet point where it talked about additional revenue to the county. We actually, what it does, it increases the amount of inventory, which spreads the tax burden further amongst all property owners. So if we didn't take any more money in the budget, it would actually reduce everyone's taxes.
Except for the first year, right?
First year, we get, new construction. Well, we don't know what the state's gonna do. That's a totally different conversation, but yeah. That's a longer conversation. But that was the only thing. And the only reason I say that is because we've had people come at us and say, well, you're only approving this because you're gonna get more money. And that's not how we look or think. We look at the law, we apply the law. That's all we do. So yeah. Any questions for the owner's representative? Nope. See, I didn't have a question. I just had a statement. So none. Okay. Anybody else from the owner's representative or the owner that wants to speak? Is that it? All good, all done? Okay. Let's go. Is there anyone here that is for? We're going to go to public comment. Anybody here for the proposed vacation? Want to go ahead and speak? Or just want to raise your hand? Either way, it doesn't matter. You get that microphone right there and you just go ahead and say your name for the.
Russ Edwards, and I'm a property owner on South Camp Bay Road. And everything that they've proposed looks really good to, I believe, everybody on South Camp Bay Road. That's about it.
Great, thank you. How about you, sir? Your 15 minutes of fame right here.
Okay, yay. So my name's Craig Gill. I own property 443 South Camp Bay Road. I've been coming to Camp Bay since 1970. My grandparents had a place on green property. So I can say in that 50 years, I've never seen any public activity going on at the end of the bay or anywhere. If there was anybody there, I think Old Man Green, Ralph would chase them out of there. Yeah, that's right. Yeah, I think he was concerned about liability. So, but yeah, so I mean, I'd love to see the bay stay exactly the way it is forever, but I don't think that's possible. And I think this plan's really a good one and will be a good thing. So.
Great, thank you. Is there anybody that's neutral? Which every time we ask that, we rarely ever get anybody that's actually neutral. Do we? Is there a hand up online? Who is it? I can't see. Bear with us. We're dealing with technology. Always fun.
I raised my hand in support.
Oh, did you? Would you want to speak? Well, we're trying to get this worked out.
I would just echo their comments.
Okay. What was your name, sir?
David Wilson. I live over on the other side around the corner on Driftwood Shore.
Oh, sure.
And so I'm for, most of my neighbors are for the development as well because it's going to pave the road and it's going to improve the property.
Okay. Thank you. And so now.
Are you gonna fix it, Milton?
I was going to stop sharing so they can have a bigger screen to work with.
I don't see where anybody else is.
There they are.
Oh, there they are. So we've got 2 hands up.
Yes.
Just go ahead and go from the top.
Oh, it says it's Gary. So, allow him to. Oh, I got that. Gary, you should be able to talk.
Gary, can you hear us?
He's muted.
Gary? He's still muted. Gary, if you want to speak, you need to make sure you unmute yourself from your end, and we'll try to make sure we unmute you from this end.
There you go.
Okay, if you
Okay.
state your
There you
name,
go.
state your name for the record, Gary.
I'm Gary Green. I'm a 10% shareholder in Green Enterprises, and I object to the vacation. I'd
Gary,
like
we're not doing, Gary, we're not doing objections yet. We are either in favor of or neutral to.
Oh, okay.
In a minute here, if we don't have anybody else that wants to speak, that is in favor of or neutral to. Hang on for a second, Gary. I'll keep you on hold for a second here. Is there anybody that's any more people that are in favor of or neutral to? Okay, seeing none. Go ahead, Gary. Sorry for interrupting you.
Okay. I would like to first point out that a petition, when this petition was filed in February, there was a case before the Supreme Court regarding Camp Bay Road. That was known, and it is in no way noted in the petition. The Supreme Court partially affirmed that lawsuit, and they've remanded another part for further proceedings. I think the Green Enterprises has done you a disservice by concealing this legal case. And in the interest of enforcing valid petitions, I think you should just throw the petition out for that reason. It has a massive bearing on the case or on the vacation, because the actual description of Camp Bay Road is what is part of the decision of that case. And so you're going to rule on something where you don't even really know, because the courts haven't decided yet what South Camp Bay Road is. I'd also like to object that if the court decides that the public road runs all the way out to the Latvala property, that there is state land, lakefront land out there where there would be public access to Lake Pend Oreille. Finally, I'd say that they showed a plan, and that plan shows no turnaround. There's no reason to vacate this property yet until they submit a plan that does show a turnaround. And also, I would like to say I would want a refund of those taxes back as far as that can be done, because currently Green Enterprises is in a de facto dissolution. The company has no income, has refused shareholders distributions for most of the last 10 years as a matter of policy. And there needs to be litigation over the basis that shareholders have in that dissolution process. So it's really premature for Green Enterprises to be vacating this when there are a number of legal issues that are still outstanding. Along with that, my mother and father made it a condition of their trust that their property would go to the Girl Scouts, Boy Scouts, and Gamblin Lake Cemetery.
And that's not for us to take up. Gary, you're out of time. And I'm sorry I didn't tell you. We've got a 3-minute time limit for people for public comments. So I've been gracious with the time, but I need you to wrap it up.
Okay.
Plus, I think it's
And
time to
finally, I would,
remind everybody that we're here to look at a road vacation and not talk about family history necessarily and a bunch of other stuff. No,
this is
legality of it all.
corporation.
That's not within our authority.
Out of our court right here.
This is a corporation. The
Gary, you're
last
stepping out of line with your comments, we are not here to discuss whether it's a corporation or not, or how that works. We're simply
And
here to look at
finally,
road
there's a big conflict
authority.
of interest with Steve Klatt, who has been an
Again,
employee.
Gary, your time is up. Cut him off. Hey, listen, I'm a very gracious chairman, and I will be happy to give you a little bit of extra time, but if you're going to ramble on about things that aren't relevant, we will cut you off. Okay, who else? Was there another person online that wanted to speak?
Yeah, so it's a phone number, last 43388.
Hey, can you hear us?
Yes, can you hear me?
Yes, please state your name for the record. And you have 3 minutes, by the way.
Okay, my name is Bonnie Lopila, and I am a property owner on South Camp Bay Road. We do not oppose the development of the Green Enterprises property. However, there should be some clarification that it may be premature. As indicated earlier, there is a pending case. We have received an award for right of access on South Camp Bay Road through the Idaho courts, and it is on remand. We have access to our property on South Camp Bay. We have not received any easements to look at. We weren't even contacted about this hearing. And so, we need to ensure that our rights of access are maintained. We were also awarded a right of utility access. So we weren't aware of this until we saw a little sign, even though the narrative indicates that all property owners were consulted. The remand indicates that South Camp Bay Road may in fact be a public road. And we did present in evidence extensive maps showing that it was on visitors maps for the Forest Service, in our court case. So our attorney, Toby McLaughlin, did submit a letter, and Lisa Moline, I believe, is there present to speak to it further. But I would like to point out that the narrative also said that there would be paving done of Camp Bay Road. If you look at the narrative, it indicates that a cost sharing proposal will be submitted to the county. So that, hasn't been established. So I just want to ensure that, our access rights aren't impacted, that we do have continuing access to our property, and that it's noted that, that our access rights may be impacted by the pending case that South Camp Bay Road may be a public road.
Okay, yeah, and we do have that as a condition if we choose to approve that there will be an easement for access for the South Camp Bay Road folks.
Okay, and again, our road needs to be extended, but we do have current access with a deeded easement over the Gill property who's adjacent to us that's on South Camp Bay. So that's what we want to clarify.
We're taking up today. We're just dealing with that portion of Camp Bay Road that is currently a county maintained road. So
And it sounds like this would actually clarify that.
mm-hmm.
Yeah, we just need to ensure that our rights of access are, we are included in all easements and utility easements when they're granted.
Right. That was stated in the owner's representative statement. So presentation. So that's included. Okay. Another hand. Randy Green, can you hear us?
Yes, I can hear you. Can you hear me?
Please identify yourself for the record, please.
My name is Randy Green. I'm a 10% owner of Green Enterprises. grandson of John Van Scravendike. This is really, would more properly be called the Van Scravendike property, I believe, rather than the Green property. That is the homesteaders. I'm objecting to this vacation of the road. For starters, there was a lack of notice to the owners. Me, my sister, my brother. My brother James was the only one apparently who knew about this. He did not notice the other owners of Green Enterprises. So there's a lack of notice right there. I only found out about this because I occasionally check to see what he's doing, because he doesn't notify us of anything. I'm also want to reiterate what's been said also, that there's this has been remanded to the district court to determine whether or not South Camp Bay Road is a public road. If it's a public road, then you cannot vacate this. So you're putting the cart way in front of the horse here. This petition needs to go way back, withdraw it and be resubmitted later once everything's decided. There's no turnaround at the property line. If you stop it at the north end of our property, we can just put a gate across there right now, and there will be no way for any grader, snowplow, anything to turn around. I mean, that's crazy.
Did you hear the presentation from the owner's representative?
Yes, I did.
Because he literally covered that. Both.
Yeah, he says he promises.
Right, and those are.
You want to get that in writing. You want to make sure that's in writing if you're dealing with my brother.
It'll be conditions of approval. So
there certainly better be, and because that's one of the things that you'll notice. John Magnuson sent a letter saying that all these things that have been decided in mediation. Well, my brother broke that mediation, and he's filed. There's property in the corner of South. There in the south part of Camp Bay Road, where he did a release of his lease that was supposed to have been changed to 30 years, and it's still at 39 years. So he is filing false documents with the county already. So be careful, okay?
That'll be worked out in court. That's not our responsibility.
Yeah, and see, that's one of the big problems with this is this stuff is not settled yet. So I say stand back and wait. Otherwise, everybody's going to be involved in litigation. And there's no reason to add an extra litigation cost to the county, until the stuff is resolved. And I want to address the dust thing. Okay, there is not going to be any change in the amount of dust until this. I don't understand this, because they're still planning on using that road, so it's not going to change the amount of dust. There's been no mention of the fact that they want to put 62 homes in there and add 62 more boat slips to the bay, which I think that a lot of people ought to know about, because they're talking about
at this point.
It is relevant. You're talking about this being,
okay, your time is up.
You're talking about this being justified for increased property tax. So if you're going to talk about this.
Okay, let's clarify one more time.
Yeah.
We need to stick to the subject at hand. We are here. We don't want to be here till 8 o'clock tonight. So let's stick to the subject at hand, please.
Okay, who else would like to stand up and speak in opposition to this plan? Yeah, please.
I hope you'll give me a little bit of latitude to sign here, because I'm going to stick to the subject.
Okay, good.
The other one too is
You still have 3 minutes. Can you, why don't you slide that microphone over so we can get you on the record there, sir?
That'll work, I'm sure.
My name is Fred Arn. I live out on Camp Bay Road. I feel really funny sitting here as a conservative, rabidly conservative Republican fighting for the people's rights, while the President of the United States is signing away our Second Amendment rights. However, it's been said that there is no public access to the lake off of Camp Bay Road. I'm going to refer you to a paper that I handed, which very clearly describes that. And this is the Idaho Fish and Game description of public waters. It's done so that those of us that are really dumb can figure it out. If you'll notice the bottom one, it shows us walking across the public right-of-way to the high water mark. All right. So Idaho Fish and Game feels that there's public access to it. I can tell you that under the Navigable Waters Act, that the conditions that you put on this for vacating, saying that it's not wide enough, there's no facilities, it's not up to us to determine that. Under the Navigable Waters Act, this is a right that belongs to the people. It's that simple. It's not up to us to tell us how to use it. We have the right, read the bottom paragraph on that paper I gave you. That's a great narrative of what we're allowed to do under the Navigable Waters Act. The other problem that I have, it says that you've reviewed, and this is in the public interest. Correct me if I'm wrong here. You're talking about vacating about a half a mile of Camp Bay Road. My understanding is that the Department of Transportation is funded, for the most part, by funds from the state, from the highway state funding. And that funding is predicated on the number of miles that the county has to maintain. If you take a half a mile of county road and make it private, well, you're losing a portion of your state funding for the county roads. So I don't know how that pans out that we're saving money. To me, that's a wash. The other one too is we talk about doing a turnaround for the buses, snowplows up at the gate. Well, it seems to me that that's required by law. So it's not really a benefit to us. It doesn't help us one way or another. It's simply compliance with the law. The second one, the other one too, is that they're going to provide an easement for the other landowners. Well, once again, this is required by law. It's not a benefit to us. And I'm talking about the taxpayers. I'm talking about those of us that have paid for this road for the last 100 years. That road has a value. And to just simply walk away from that value, it, for me, just doesn't make any sense. I'm having a hard time understanding. Now, I heard the PowerPoint. I wish I had that kind of time in a PowerPoint. I could have done a much better job than what I'm doing now, but there are a lot of myths in that. Okay, there are a lot of myths in that. And I'll tell you, I went down there and was accosted by the Green family who threatened to call the sheriff and have me arrested. I told them to do that because I wanted to bring this thing to an issue. They wouldn't do it. So there should have been 23 calls to the sheriff and there wasn't. They wouldn't challenge me on it. They know that that's public access. I'm done. I'm gonna refer to my wife.
Great.
Any questions?
Nope.
Okay.
I'm Jennifer Arnn and I'm married to Fred. And we live on Camp Bay Road, 1906. We purchased in 2012. Before that, we were in Rathdrum. And I want to respectfully ask, please do not vacate this portion of Camp Bay Road. It's not in the best interest, public interest. For Lake Pend Oreille being one of Idaho's, well, being Idaho's largest lake, there are surprisingly very few public access points to the lake. As the population of Bonner County increases, as you know it is, this is going to become more and more important. And yes, clearly, the end of Camp Bay Road is a public access point. And I can read specifically from the under the public trust lands from their Idaho Department of Lands on their website. And also I talked to the director of the waters, Andrew Smith, about this, and he agreed, but it says, upon statehood, Idaho gained title to the beds and banks of navigable waterways below the ordinary high water mark under the equal footing doctrine. The state holds these lands in trust for the benefit of the public. Title to these lands is held in trust and is administered for the public benefit rather than for a specific beneficiary. Idaho Department of Lands manages these lands to provide for the commercial, navigational, recreational, and other uses. And I know you're talking about a road, but if you vacate the road, there is, which dead ends, as clearly has been stated, at the high water mark in the lake bed, meaning that I have access to step from the the road, the public road to Lake Ponderay. And at this point, with how it is, it's not walking through anybody's yard. It's just simply walking across. I spoke with many, many people as a last minute sort of thing. We got some signatures and many people had stories of being chased off by Ralph Green or different times that they had jumped in and swam. And one particular episode when we had gone down there with our truck and my husband pointed out that we had right. It's well, but they acknowledged that, yes, we had right on there. He said, just as long as we don't park on his property, that we parked up on the county road. And nobody needs to develop this land. It's fine how it is. I can't tell you how many people walk down there and see it and walk across it and just enjoy the lake. And once you give that up, it's gone forever. There are so few points to be able to access the lake, and we don't need bathrooms. We don't need any of this. Okay, well, please consider, and you have this. Am I completely out of time? Okay.
Went a little bit long, but that's okay. Pretty easy.
Thank you.
I gave him like that.
Unfortunately. She took every bit of it. Okay, anyone else that want to speak in opposition? Go ahead, ma'am.
Good afternoon. My name is Lisa Moline. I'm an attorney here in Sandpoint for Berg, McLaughlin, and Nelson, and we represent the lot Lavas. I would like to mention that they are the last property on South Camp Bay Road. I would like to point you to the current existing district court proceeding that's going on. By vacating this road, you are not clarifying this issue. In fact, it's quite the opposite. It went to the Supreme Court. It's being remanded now. So I think what I would like to say is this a little premature. My clients are not opposed to the development. They're not opposed to the vacation. I just think it's premature. I would mention that there's been a lot of talk about this easement. Currently, the easement that I have reviewed is temporary. It's not a permanent easement. My client does not know what the terms of a permanent easement would be. It is, I think it's unfair to vacate the road without my client knowing what kind of access she's going to have. With regard to easement laws in Idaho, the burdened property gets to choose. So you can tell them, the green property, you have to put an easement over your property for the benefited parcel, which is my client. They could make restrictions on that easement all day long without my client participating in that. So just telling them that they have to have a condition of an easement is still very low. It's a low burden. It doesn't provide quality access to my client. And so I think that there needs to be some additional restrictions on that. If you require an easement to be in place, that my client gets to participate in the language of that easement. There could be cost shifts and burdens that my client doesn't get to participate in, which ultimately eliminates their access that's free at the moment. So I think it's important that you realize that just conditioning this with an easement is not enough. There needs to be additional restrictions on that. And of course, it's premature because of the litigation pending before the district court. I think that's been talked about a lot. I think Toby McLaughlin has put a letter, and so I won't reiterate all of that. I think the law is very clear that intent isn't enough. It needs to be in writing. We haven't seen it. That's not, it's not in the best public interest if we haven't had the ability to actually participate in that easement. Right now, it can be revoked. Temporary easement is just a license and it can be revoked at any time. So again, I think I'll just reiterate, it's very premature. We're not against it. I think it's premature. Do you have any questions? Probably not.
Thank you.
Anyone else like to speak? Nobody? I'd like to take a second before we allow the owners to represent. Do we have another one?
No, I just want to address for the owner, but I have a court hearing at 3 o'clock, so.
Okay.
but if you're gonna take a break, that's all in there.
Oh, yeah, we're not going to take a break. But what I wanted to do is I wanted to actually bring Bill in, talk to him about this whole.
Well, or let their attorney. read.
Yeah, do you have,
Yeah.
you there? Yeah, come on in. Good.
Hi, first of all, it's Paul Doherty. I live at, well, actually,
Yeah, we don't
office.
trust any
Okay,
outside
all right.
We only trust our own.
505 East Front, Suite 301, Coeur d'Alene. I want to point out that the things that were said about the easement are actually patently false. I think that if you look at this case, and I don't want to bring in all of the issues about Green Enterprises, I've been dealing with them for 2013. I think that John Mason did an excellent job in his emails to you. He gave you the Supreme Court case that says what it says. All the lot fellows have are what they have. And that's what the Supreme Court says. The purpose of the remand was very limited for that purpose. The court said what the lot fellows have is access, but basically they have access if they want to have a mining claim. They can't have a residence there. And I think that's what that Supreme Court ruling says. If you read it, it's very clear on that. So then we get to this issue of the public access. We have to remember, we're not talking about the lake bed. The thing I would point out is that no agency, including IDL, submitted any objection to this request. If there was an objection, if they had a concern, they're the proper party to bring that concern, and they've not done so. Nobody's done so. I've been doing real estate law for 30 years, mainly down in Coeur d'Alene. I deal with issues all the time where people are unhappy with a development or people with unhappy about a proposal. I can't tell you the number of times people said, I don't want this to happen because that's where I ride my horse. I said, well, you don't own the property. But that's where I ride my horse. In this case, all we're asking for is a vacation of the road. County staff is in favor of it. It complies with the law, and that's what your duty is. Does it comply with the law? It complies with the law. There is no legal basis to put this off, and there's no legal basis to deny it. And what they're asking makes sense. It's reasonable. It is no different than any other vacation for something like this. And I would urge you to not get lost in the blue smoke and mirrors, so to speak, but to focus on the legal issues. The lot fellows have whatever right the Supreme Court says ultimately they have. That will have to transfer over, and everybody knows that, everybody acknowledges that. So I would ask you to approve the application. If you have any other questions, I'm more than happy to answer them.
Any questions? Owner's representative, you get an opportunity to rebut.
Or do you want Bill to weigh in now?
No, I don't trust Bill anymore.
Is there anything?
He's got the suit on, so he's got the, you know.
He's got the.
Yeah, let's talk
You
about
have
your,
to come to
your
Mike
fashion
also,
sense.
Bill.
No, I'm just kidding.
I would like to make a comment.
Mike.
Can you please identify yourself for the record?
Bill Wilson again for the record. Apologies if I didn't stand up here the first go around. I did this public trust doctrine. I'd like to comment on that a little bit. That is for those waters that are below those grounds that are beneath the ordinary high water mark. And actually, for a little bit of clarification, if you look at the first paragraph of 40-203, which is the statute that governs these vacation proceedings, they do say that that the county or highway district system gives you the right to, abandon or vacate roads within your jurisdiction. In the county or highway district system, including those which furnish public access to state and federal public lands and waters. So I think that's directly applicable to where we are today. It does give you the right to do that. So I think that is a misplaced point of focus. As to this other pending case, I think at least the attorneys in the room agree that it's not a influence your decision, but it is by no means a bar to vacating the road today. It might have legal ramifications down the road, but simply not something you should take into consideration.
Right. Okay, great. Thanks, Bill. Okay, now owner's representative, you get a chance to rebut if you wish.
Again, Brad Marshall, JB Engineers.
Any other attorneys in the room that wish to speak? How many attorneys?
I'm not an attorney. I'm a planner, although I've worked in the legal world for 30 years.
Attorneys, I think.
Are we going to get an opportunity to rebut?
No.
But
They're getting the opportunity.
No, that's not the way. I went over the way the hearing works. Hopefully you were paying attention.
Yeah. Again, we've worked hand in hand with your departments. We submitted an extremely strong application. We've worked with the adjoining property owners. Our application meets the criteria of the vacation. Your staff has recommended approval. The agencies have not opposed it, particularly IDL. I think it's a key point, they've tried to kind of muddy the waters on the easement. That's almost the adjoining case irrelevant, and we've addressed that with Mr. Magnus's letter. I can tell the commissioners, you're a sharp group of guys and you've read the report, you've read the agencies. I'm not going to cover a bunch of irrelevant stuff. I think its key point is Milton does have a copy of the proposed access easement. And as a temporary easement that converts to a permanent easement, so it protects all parties involved. I want to remind you of the sequence. So we approve the vacation, then we record the access easements, then we record the boundary line adjustment. So there's a process there that protects all parties. And it's the advantage of the Green family, whether an M3, the county, to have all this work concurrently. The last thing we want to do is have something that doesn't protect all parties. With that, I respectfully request approval.
Okay, just a quick question, just for interest's sake. Would the folks you represent be interested in including the South Camp Bay folks in on the negotiation of the easement, or have you reached out to them to make sure they?
We've shared a copy of that draft with them. Yeah. So we'll certainly be working with them.
Sure, copy that draft also with Toby.
Yeah, with Toby.
I just want to make sure we touch all.
And a
bases.
reminder, it does convert to permanent. Thank you so much.
All righty. Do the commissioners have any questions for the owner's representative or staff before we close public comment? I do not. Okay, hearing none, let's go ahead and close and deliberate. So I wanted to touch on a few things here. And thanks for the blue smoke and mirrors comment. This obviously is not our first rodeo, and we've been down this road before, but I wanted to specifically speak to this gentleman in the back, being a conservative, and I think we're all conservatives up front here. One of the basic planks of the conservative platform is private property rights, which means your private property rights don't exceed someone else's private property rights. And what we're talking about is private property. We're talking about an old Views Report road that dissects someone's private property. That's asked us for some relief. As it was stated, the agencies, including Fish and Game, had no issue. We've already discussed the Navigable Waters Act issue. As far as cost of maintenance, you probably don't understand how much it costs to maintain these gravel roads. We're actually dealing with a lot of issues because of that. And to a degree, this is a win for the taxpayers of Bonner County because this will be one less gravel road that we've got to deal with. They are costing us an exorbitant amount of money, and we're looking to take steps to hard surface those because it dramatically reduce the cost of maintenance, roughly about $280,000 over a 20-year period. So while I appreciate your concerns, really not that valid. We've discussed the tax revenue issue and the state lands access. That was kind of a curveball, I heard, but without looking at the map, I don't know that that's even a relevant argument either, because I know there is access to that state land from the other side, because I do know the area well. I'm inclined to approve this because we are here to follow the law. We are here to look at just those things before us and that are within our authority. And it clearly looks like all the boxes have been checked here, and there's no reason for us not to approve this vacation. Mr. Conley?
Okay, so one of the things that I notice is I don't think I want to live in your neighborhood because it's a pretty litigious neighborhood. I think I'll stay away from your. The thing is this should have been able to be settled on the ground in a fashion that everybody could stand around a campfire and talk about it and make it happen. It isn't. And it seems like every time we meet one of these really off the wall type of situations like this, it's always because somebody doesn't want somebody else to do something. And again, I'm glad you called that out about us all being conservative, because we are very conservative and we prove that time and time every day. To me, this is nothing more than a smokescreen to try to keep these folks from being able to have the right to develop this property. It should be able to be solved. I think that anything and everything that we've heard here today can be solved with the direction that the applicant has pointed out. So I would be in favor.
Okay. Mr. Bradshaw.
My first initial struggle when I first started looking at this was the current price of real estate in Bonner County, how do we justify giving away 3 acres at what land is going for now? But what we spend in road maintenance over the period of time, access is guaranteed to everybody that's involved in it. They're taking what access is there, making it a better access from what I can understand. I understand public access to waterways because I have a waterway that cuts my property half in two. And there's a lake association that wanted to contend that they can cross my property and walk that creek anytime they want to. And I told them they can walk the creek, but that does not mean they can cross my property and do that. Not that I mind, but I have that right to tell you, no, you cannot cross my property. But if this was in fact a public access to the lake, IDL and Fish and Game would have jumped all over that. They would have been very loud. I'm very familiar with that area. I've worked on a lot of those houses on South Camp Bay Road and a couple of them on the other side. Over the past 30 years, I've been here since '88, so I'm very familiar with Camp Bay Road. And I see it as a plus for everybody involved. It saves the county road money. It gives a better access for the people that live there. And it allows you to develop good property. And it seems like the developer is certainly going through all the proper steps. And like I said, I struggled with it at first because we're giving away 3 acres. How do you make that sound good? Until you look at all the details involved. And then once you look at it, it makes sense. And I think at the end of the day, when it's all done, I think the people at both ends of that road are going to go, this worked. This was a good thing. And I don't know of anybody in Bonner County that doesn't want a paved road.
That's for sure.
So, yeah, that's where I'm at on it.
Okay, well, if deliberations are complete, then I will go in and entertain a motion. Who would like to get it?
Okay, Mr.
Go on,
Chairman, I
volunteer.
move to approve this petition file VS 0002-21, a petition to vacate a 2,550 foot portion of Camp Bay Road as shown on the submitted site plan, finding that it is in accord with Idaho Code 40-203 as enumerated in the foregoing conclusions and based on the evidence submitted up to the time a staff report was prepared and the testimony received at this hearing. I further move to adopt the following findings of fact, conclusions of law, conditions of approval. The action that could be taken to obtain the vacation is to complete the conditions of approval as adopted. This action does not result in the taking of private property.
I would second that.
Okay, we have a motion and a second. All those in favor say aye.
Aye.
Aye, motion passes. Now the resolution adoption. Jesse, do we have a number?
37.
37. And is this roll call vote?
It is not.
Okay, good. Thank you.
You can do that one, Steve, or you want me to?
So I move to approve resolution 21-37 vacating 2,550 feet portion of Camp Bay Road as shown on the submitted site plan.
And I'll second that.
Okay, we have a motion and a second. All those in favor say aye.
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 Aye, motion passes. And with that, it is pretty military time. It's 2:43, and we will go ahead and adjourn this hearing.
Thank you.